Now let's begin with judicial precedent. Precedent is a major source of law. It's based on case law, which is when a dispute is settled by a court. Okay, so the person applying the law in the court is the judge. So how does the judge apply the law? By following the principles of precedent, which works like this. Depending on the importance of the court that decided the earlier case, the judge in the present case either A, must follow the early decision, or B, may choose to follow the earlier decision. In short, past decisions make law for future judges to follow. The idea here is to make the law fair and certain. Precedent is normally split into two parts: the general principles or key elements of the doctrine and its practical application through the court system. The elements of the doctrine of precedent which you have to learn are ratio decidendi and binding precedent, obiter dicta and persuasive precedent, distinguishing on the facts, overruling and reversing, and per incuriam statements. Ratio decidendi literally means the reason or reasons for the decision in the case. At the end of each case, the judge makes a speech in which he states the decision in the case and the reasons for that decision. This is called a judgment, which also contains summaries of the facts of the case, the arguments put by lawyers, and often the relevant case law, plus general comments by the judge. A court hearing a later case is not bound by everything said in the previous case, but only by those parts of the judgment that lay down the legal principles for the decision in the earlier case. This is the ratio, the part of the case which lays down a precedent for future judges to follow. There can be a problem in working out what the ratio of the earlier case is, particularly where there is a multiple judge court, as in the Court of Appeal or the House of Lords, and each judge gives a different reason for his decision. We need to relate the ratio to the idea of a binding precedent. This means that a precedent laid down in an earlier case must be followed by the judge in the later case, even if that judge does not agree with the point of law laid down. Precedent used to be thought of as merely declaratory. So simply put, in deciding a case, all the judge has to do is declare what the law is. This makes judges seem like machines, simply following what is already there. But the modern view is that judges are creative, especially where there is a situation or point of law which has never been decided before. In such cases, the judges will lay down a new precedent, as in Donoghue and Stevenson. So what happens if a judge is faced by a new situation where there are no past cases to help him? Well, he can look at cases which are closer in terms of general principle and follow them. This form of creative thinking can result in problems. For example, what happened in the case Hunter and Canary Wharf? Here, a 250-metre-high tower was built in the East End of London. Local residents brought an action for nuisance, claiming that the tower was the cause of interference with TV reception in their homes. There was no existing point of law on the interference to television signals caused by the erection of such a building. The judge in the case accepted a comparison with the existing law on the loss of a view from a house. The loss of a view was not actionable in law because enjoying a view was not thought to be a necessity. The judge in this case, while accepting the importance of television in people's lives, also thought it was not actionable because it was not a necessity. Do you think this is a fair comparison? Are the two situations equivalent? The decision is what matters to the parties, whereas the point of law is the crucial issue for future judges. However, a judgment will also contain other statements made in passing. These are called obiter dicta. It is wrong to think that such statements, although not necessary for the decision in the case, are completely unimportant. If such dicta are used in a later case, they may become binding if they are part of the later ratio. Is there any way to tell when a judge is making an obiter statement? Often the statement is a what if or hypothetical proposition, for example, a statement of law based on a situation not covered by the present facts or statements of law, which is not part of the decision in the case. An example of this is the case of Hedley-Byrne and Heller. In this case, Hedley-Byrne entered into an advertising contract with a company called Easy Power. Before confirming the contract, they sought a credit reference from Easy Power's bank, Heller. The bank confirmed Easy Power's creditworthiness, but marked their reference without responsibility. On these facts, the court held the bank was not liable because they had disclaimed any liability arising from their reference. This was the Rottier of the case. However, the what-if point made by Lord Pearce in his judgment was this. If the bank had not excluded its liability by including the without responsibility disclaimer, then they could have been liable for negligent misrepresentation. This obiter statement became the basis for subsequent developments in the law. If a judge gives two reasons for his decision, then they are both equally binding. However, we have to remember this. It's not the judge in the previous case who decides what the ultimate Rottier will be. This is decided by later judges who may take the view that one of the reasons is essential to the decision, but the other is not. The other is then treated as obiter. Persuasive precedents. Obiter dicta belong to a category of precedents which are not binding, but are considered persuasive. So, for example, the judge in the present case decides to follow them because he agrees with their reasoning. One of the most famous and memorable examples of this was in Donoghue and Stevenson and the neighbour principle. Other categories of persuasive precedent include decisions of Commonwealth, foreign, Irish and Scottish courts. Thus, the House of Lords in Junior Books and Vichy was influenced by an Australian case, Caltex Oil and Dredge. Decisions of the courts inferior to the one hearing the case. The most famous recent example of this is the case of R&R, which established that rape within marriage was a crime. The precedent was laid down in the Court of Appeal and followed by the highest court in the system, the House of Lords, which agreed with the legal reasoning of the Court of Appeal. Decisions of Judicial Committee of the Privy Council. This is where the House of Lords judges hear appeals from Commonwealth nations. These decisions were traditionally seen as merely persuasive, for example, the Eurymedon. But since Doughty and Turner in 1964, the Court of Appeal has treated decisions of the JCPC as binding. Distinguishing on the facts. So far, we've seen that precedent is based on the idea that the important facts of the later case are similar to those of the earlier one. This is summed up in the phrase, treat like cases alike. It seems to follow from this, that if two cases are sufficiently dissimilar, then the earlier case need not to be followed. But what does similar mean, and how does a judge decide which facts are important? Surely it's possible to distinguish any two cases, since factual situations are highly unlikely to be exactly the same. Well, imagine a 25-year-old woman driving through Manchester on a rainy day at 11 a.m. She's listening to a CD and singing along, not noticing that her speed has crept up to 35 miles per hour in a 30-mile-per-hour zone. She also fails to notice a 55-year-old man stepping out from behind her car. She hits him and he is seriously injured. Would the precedent in this case be that 25-year-old women driving carelessly through Manchester at 35 in a 30 zone be liable to 55-year-old men who suffer injury because of their negligence? I think not. If so, this would be an unrealistically narrow view of precedent, which would rarely apply because a large number of facts would have to be duplicated. Okay, so in reality, the precedent is likely to be much broader. If A injures B while driving carelessly, then A will be liable. This would cover a huge range of possible situations. This makes so much more sense. The important facts are limited to driving carelessly and injuring someone. Distinguishing on the facts introduces flexibility into the operation of precedent, but the concern is that judges sometimes use the device to get round old precedents they don't like. Judges have a lot of discretion in this area, and some of them are more inclined to distinguish old cases they disapprove of than others. It is often stated that a case can only be distinguished if it is reasonable to do so, but this isn't actually very helpful, as what is reasonable still depends on the view of a particular judge in a particular case. So, distinguishing is an important tool for maintaining fairness and flexibility in the system. But if it's done on inadequate grounds to avoid a disliked precedent, then it will undermine the system by creating uncertainty. Okay, so we have a real dilemma here. If an old precedent, which the judge considers to be out of date, is not distinguished, then the bad law remains in place. If it is distinguished on inadequate grounds, then uncertainty is created and the doctrine of precedent is undermined. Judges try to avoid awkward precedents by arguing that they are outdated and no longer in line with modern thinking. Two cases from contract law that illustrate some of the issues discussed so far are Balfour and Merit and Merit. Let me explain. There's a general presumption that agreements between husbands and wives are not legally binding. In Balfour, it was decided that the wife's claim for breach of contract could not succeed because there was no intention to create legal relations. In Merit, however, the court distinguished the earlier case by saying that in the present dispute, the agreement was made after the husband and wife had formally separated, so they weren't living as man and wife. But if we look at these cases in more detail, we find that Mr. Balfour had also been separated as he was living with another woman, even though there had been no formal separation from his wife. It could be argued that the significant difference between these two cases is to do with changing social attitudes rather than material facts. The Balfour case was in 1919, when the attitudes to marriage were very different from those in 1971, when the Merit case was considered. Overruling and reversing. Overruling is simply where a court in a later case states that a decision in a previous case is no longer good law, either because the previous court got the law wrong or because the later court thinks that the rule of the law in the previous ratio is no longer desirable. Right, now this is really important. Overruling can only take place where a higher court overrules the early decision of a lower court. Okay, so two final points. You can't fall asleep yet. Firstly, the European Court of Justice can overrule its own previous decisions, as can the House of Lords under the practice statement of 1966. And a precedent can also be overruled by an Act of Parliament. Hopefully, you will have heard of the term reversing. This simply means that the decision of a lower court is overturned or reversed on appeal, thus changing the result in the case. Per incurium statements. A decision reached per incurium is one made through want of care. So a Court of Appeal decision made per incurium is not binding on subsequent courts of appeal. Lack of care doesn't mean the case was badly argued or the judgment poorly reasoned. It has the restricted meaning of failing to consider a relevant statute or precedent. The principle isn't usually applied, but can be applied in courts except for the Court of Appeal. Let's explore the exciting hierarchy of the courts. Yes, I did say exciting. Okay, starting with the European Court of Justice. Amazingly so, since 1973, on all matters of European law, the decisions of the ECJ are binding on all domestic courts of member states. The ECJ isn't strictly bound by its own previous decisions, though it does tend to follow them, so it's more flexible than our law. Next, the House of Lords. Now this is bound by its own previous decisions, from the time of London Street Tramways and London County Council, into the practice statement which said that the House of Lords recognised that too rigid an approach could lead to injustice in certain cases and stop the proper development of the law. So, while previous decisions would be normally binding, they could depart from a previous decision when it appears right to do so. Moving on to the Court of Appeal. This is bound by the European Court of Justice, House of Lords, Judicial Committee of the Privy Council, and its own previous decisions. Bound means it has to follow their decisions. This is subject to 3 exceptions laid down in Young and Bristol Aeroplane. Next, we have the Court of Appeal, Criminal Division. This is bound by the European Court of Justice, House of Lords, and subject to the Civil Division exceptions, plus the additional exception that the court should not be bound by its own previous decisions where this would result in injustice. Still awake? Fantastic. Nearly there. Let's go on to the High Court, Divisionals. The 3 divisional courts. We have 2 to 3 judges sitting, and it is bound by the European Court of Justice, House of Lords, and Court of Appeal. Now I hear you ask, are they bound by their own previous decisions? Well, they follow the Young and Bristol Aeroplane formula we mentioned earlier. Then we have the High Court, First Instance. This is bound by all the courts we've mentioned and binds all the appropriate lower courts. The decisions of other High Court judges at first instance are merely persuasive. OK, we come to the court Zara was standing outside to introduce law, the Crown Court. It can lay down a persuasive precedent on a point of law which magistrates would be expected to follow, although this doesn't happen very often. Last but not least, the courts most people will have heard of, the magistrates, county courts and tribunals. These are bound by all superior courts. They don't create precedents, only follow them.